I'm delighted to be joined by John Bowers QC and Mary Inman. This is the first of 2021's monthly speaker events for the employment group of the Society of Labour Lawyers. I said I would do one every month. It's taken me a quarter of the year to actually organise one, but here we are. This is a really interesting topic that we're going to be discussing tonight, and we've got two absolutely stellar leading individuals to do it. John Bowers QC, who of course is a leading employment law silk, former head of my own chambers. Indeed, he was the head of chambers when I was taken on as a tenant all those many years ago, and now the Principal of Brasenose College, Oxford. Mary Inman, who heads up the whistleblower practice at Constantine Cannon, and I'm hoping is going to give us, I recognise nearly all of the names on the attendance list there. I think I'm right to say that, Mary, you're going to be giving us all an education in transatlantic, United States, global whistleblowing law. So I'm not going to dwell any further. As I've said, we are recording this event. I'll hand over to John to talk about his recent report, Whistling in the Wind, and then we'll go to Mary, and hopefully they can riff off each other and we can ask them some questions. So no more from me. Over to you, John Bowers QC.
Yeah, well, thanks very much for the invitation. Delighted to be speaking with Mary as well. I'm just going to talk about some proposals for reform of whistleblowing. Just as an introduction, I think whistleblowing is essential to the rule of law and is a very good thing normally, but whistleblowers must be protected. Defining exactly what a whistleblower is not easy. I prefer the version of the Government Accountability Project, a US advocacy group that describes the whistleblower as a person of conscience who uses free speech rights to challenge abuses of power that betray the public trust. And I think that brings together the human rights element, the employment law element, and the fact that this is an important part of achieving regulatory superintendence of wrongs in society. And I think in a way, conceptually, the UK law needs to be updated because it was seen very much as an employment law issue only when the Public Interest Disclosure Act was passed in 1998 with all party support. But it does now need to be reviewed, not least because only 12% of the cases that get as far as an employment tribunal are successful. And many whistleblowers who you speak to are quite unfulfilled because regulators often ignore what they say. The All-Party Parliamentary Group on Whistleblowing stated in a recent report that the UK regulatory framework of protection is complicated, overly legalistic, cumbersome, obsolete, and fragmented. Well, that may be putting a bit too high, but there is an element of all of that. In fact, they also said that Public Interest Disclosure Act is the equivalent of having teeth extracted without an anesthetic. Whistleblowers, of course, have all sorts of motives for doing what they do, ranging from pure public spiritedness to, in a few cases, enmity towards the employer or something which is more mercenary. Very often, blowing the whistle can lead to trauma for the whistleblower. Many feel strongly that the legal system fails them at the moment, so they're shunned and avoided. What is clear is that there are many hurdles placed in the way of the genuine whistleblower, and often they're presented or are represented as trouble or the other. Retaliation against the whistleblower is a common theme. And what is particularly insidious is that a whistleblower may be blacklisted in his or her future career. A whistleblower was told by a recruiter, for example, I've Googled you and you come out as a whistleblower, and I don't want to jeopardize my relationship with my clients by taking you on. So what the whistleblower often wants is for a regulator to intervene and investigate his or her complaint. But there is a real fragmentation of the regulatory framework and no duty on employers or regulators to investigate whistleblowing concerns. And the whistleblower cannot make a direct legal claim against a regulator for mistreatment or being ignored. Now, there weren't that many proposals for reform until recently, but like London buses, two came along at a similar time. That's Philippa Whitford's Public Interest Disclosure Protection Bill and Baroness Grahame's, and also Protect has its own draft bill, as does Whistleblower UK. These are the things that I think should be part of a Labour government's approach to whistleblowing. Firstly, that there should be a legal standard on the employer to bring in whistleblowing arrangements, including a requirement to give whistleblowers feedback on the concerns raised, provided it got over a particular hurdle, that it wasn't in bad faith and there was reason to believe that it might be true. The Secretary of State should have power to issue codes of practice to raise those standards. Secondly, where whistleblowing standards are breached, there should be criminal penalties. I think only this will focus attention by recalcitrant employers. Thirdly, there should be some protection for whistleblowers against cost penalties in the employment tribunal. Some whistleblowers have encountered bankruptcy for their pains, and this should be treated like the environmental field, where pressure groups have cost protection. Fourthly, there should be a wider protection for groups that are not covered at the moment, particularly non-executive directors, volunteers, and job applicants. Probably the whole area should be analogized to discrimination, so that it would be rendered unlawful to discriminate, victimize, or harass an individual for a protected disclosure. And that would also pick up where people are being turned down for jobs because they've been whistleblowers in the past. Fifthly, there should be some form of whistleblowing commissioner, an independent body to investigate concerns. Whether that should have enforcement powers, as Whistleblowing UK wish, I think is a more open and debatable question. I think it should sit alongside employment protection rights. There should be whistleblower champions on boards or management teams. There should be periodic audits of the effectiveness of whistleblowing arrangements. The use of gagging clause should be tightened up further, although this is a complex area and is already covered to some degree. There should be more availability of punitive damages. And I think that we should look at rewards for whistleblowers. Somebody called Bradley Birkenfield, who actually went to prison in relation to whistleblowing actually then later received from the Inland Revenue Service a reward in 2012 of $104 million for whistleblowing that netted the Internal Revenue Service a good many multiples of that figure. Now that's at obviously the high end of the scale, and there are some real problems about rewards for whistleblowing that changes the motivation. Most people don't do it for money, but I think we should look at that. So Grahame, I've had my 10 minutes. Be delighted to take questions, and looking forward to Mary's presentation. Thank you very much.
Great, thank you, John. We'll hand over to Mary first. Mary, I've made you a co-host. I hope you can share the slides that you wanted to share. Lovely.
Thank you, Grahame. Thank you, Paul, for inviting me. It's a real pleasure to speak with you all. I moved to London 3.5 years ago to launch our firm's international whistleblower practice. And one of the motivating factors was that we are seeing data out of the SEC, our securities regulators, whistleblower program, showing that for year on year, we have about 10 years worth of data. The United Kingdom supplied the #1 source of whistleblowers to the SEC program outside of the United States. So we thought it seemed like a good area for us, and we were not disappointed. So I want to talk about the experiment we've been undertaking in seeking to attract UK and international whistleblowers to the US programs. But before I do that, I just wanted to share a few quick slides to acclimate you to what we mean when we talk about the American whistleblower programs. I am an unabashed advocate, unapologetic advocate for these programs, but I want to say that in the eyes of American exceptionalism, we may be exceptionally good at reward programs. I think we're exceptionally bad at our retaliation laws. So I'm learning a lot by being here in terms of, we have basically a patchwork quilt of retaliation protections for whistleblowers, and we really need to even follow PETA's example of having an umbrella law. So I'm going to limit my remarks to reward programs. I'm going to give you a whistle stop tour and then open it up for what I hope will be lots of questions. Are you seeing my screen? Yeah? Sounds like it. Just a second. Trying to get it in slide view. Why aren't we going to slide view? Just a second. Technical difficulties. Okay, here we go. So we just sort of described to you what whistleblower reward programs are, but what they really seek to do is to match and sort of do a matchmaking function between United States regulators who need whistleblowers' information and the whistleblowers who can bring them sort of invaluable, often inside information that will put them on the scent of the trail of some very significant frauds or wrongdoing. So I want to start by the conception of who are the whistleblowers. John talked a little bit about motivation, and under the US programs, we welcome all types of whistleblowers. While our programs initially started with the prototypical whistleblower insider, our concept of who can be a whistleblower has evolved as our programs have evolved. So in addition to insiders, we have started to see some very successful cases by whistleblowers who were outsiders or competitors, or in fact, even people with expert information who take publicly available data and show the government that there are trends. So we'll talk about our SEC program, but it was inspired by a gentleman by the name of Harry Markopoulos, a financial advisor, investment advisor in Boston, who exposed the Bernie Madoff scheme to the SEC. He didn't work for Madoff. He was just an investment advisor who said these types of returns are statistically impossible. And so when he was routinely ignored going to the SEC 3 times, it was that and his example that inspired the Dodd-Frank legislation to create an office of the whistleblower. So it's not just insiders, it's outsiders like Harry Markopoulos with expertise who have that sort of unique window into certain practices, that we welcome their information as well. You don't have to have clean hands. Our original whistleblower statute was adopted. It's called Lincoln's Law, so it's 1787. Which for Americans is a long time ago. It doesn't have anything on the Brits, but for us, that's ancient history. And the concept from the legislators at that point was it takes a rogue to catch a rogue. So we don't expect you to have clean hands. In fact, some of the most important whistleblowers, as you can see from the Met Policies, from confidential informants, are people who are themselves compromised. They have to be compromised to be working at some of these organizations. But let's be clear, you cannot be the architect of a fraud and then benefit from it. So you can't create a fraud and then receive a reward. But as long as you can point upward to someone who basically constructed it, you can be a co-conspirator and still receive a reward. Most importantly, for my new line of business, is that you don't need to be a United States citizen to bring this information forward. In fact, the SEC and the other programs I'm about to discuss all welcome. They have signs, blinking signs that say international whistleblowers welcome. So just a quick overview. Here are the reward programs that we have. Jumping around too fast. We have our False Claims Act, which is actually something I think that I would promote in particular for the labor government, as Boris is considering unprecedented levels of defense spending again. What the False Claims Act allows lawyers to do, launch a lawsuit in the name of the government. They actually are party to the lawsuit when they know that private contractors are defrauding the government. So if Boeing is selling defective 737 Maxes to the Defense Department, whistleblowers can launch those cases, bring them to the government, and actually be in a public-private partnership, providing not just the whistleblowers information, but law firms like myself are private resources to help underserved, underpaid, understaffed government prosecutors. Because of the success of the False Claims Act, it has spawned these three on the right, which are our agency programs. So they all decided, hey, we want to get in on the act. It seems like these whistleblowers provide a roadmap to the fraud. The DOJ touts them as their #1 enforcement tool, most effective enforcement tool. So that has spawned what we call the agency programs, where under the SEC, our tax authority, and our Commodities Future Trading Commission, if you supply a tip to the government, you can receive, and that tip spawns an investigation that leads to the imposition of a fine. The whistleblower can get 10 to 30% of the award. Just this year, we adopted a new one. So we're getting crazy with our love of these programs because they've really paid rewards and dividends. So in January of 2021, we now, as a result of the FinCEN files investigation, the Treasury Department and FinCEN, our financial crimes enforcement regulator who deals with the Bank Secrecy Act, the equivalent of the UK Bribery Act, are allowing whistleblower insiders to bring information to the US Treasury and consent and receive up to 30% of the award. So I think it's more of a factor of success begets success. And one of the things we should talk about as we get into questions is that Canada has adopted a copycat of the SEC program for the Ontario Securities Commission. So companies traded on the Toronto Stock Exchange who are engaged in accounting fraud, insider trading, now have a similar vehicle to the SEC. I think the differences are something we should discuss because they actually put a cap on the amount of the rewards that a whistleblower can receive, a cap at 5 million, whereas the American programs are all uncapped. And they also lower their range. Instead of 10 to 30%, they only allow 5 to 15% of the recovery. So I'm going to skip just really quickly to jump more to the figures to talk to you about how these programs have been successful. So what we're seeing here is that about 15% of the whistleblowers coming to the SEC that have been successful in prompting enforcement actions have come from overseas. Here's the data I really wanted to focus on, which is that outside of the United States, the SEC tracks countries of origin that whistleblowers are coming from, and year over year, the UK has been #1, except in the past couple of years where you've been outpaced by Canada. And my view is that I think the reason, this is supposition, but the reason I think is that Canada now has its own whistleblower reward program, and I think that has increased awareness. So I've given you examples. Before I get to the statistics, I just want to show a cheeky picture. I took this picture at the International Derivatives Expo. Took place in London. This is a trade show booth that the CFTC's whistleblower office set up beside all the other fintech vendors. And they are giving out swag that has the number for the whistleblower office to call for the CFTC. So if you doubt that whistleblowers are valuable to our regulators, they actually, in some instances, are entrepreneurial in seeking these folks out. And of course, I would love to have the trade show booth right next to their booth, but we'll see if I can get that. So just some numbers and then I'll turn it over. I think this is really important to look at these numbers when we think about HMRC's program. So HMRC has a discretionary program for whistleblowers revealing tax fraud. The SEC had a similar program. This is how much they've paid out in rewards during the 11 years of that program versus that was pre-Dodd-Frank, post-Dodd-Frank, when whistleblowers had the certainty of knowing it's not in the agency's discretion, it's mandatory, you get 10 to 30%. There's actually an office of the whistleblower for whistleblowers to come to. We have since had $760 million paid out in rewards to 146 whistleblowers. That number has gone up since I just fixed those slides 3 days ago. Those whistleblowers have helped the SEC impose over $2 billion in fines. So I would say it's a pretty good rate of return. One of the things we should discuss when we get to the questions section is that the SEC has actually taken on board criticism that it had been slow. It gets 6,900 tips a year now. The average amount of an award is $5 million, despite the fact that there are some big eye-catching numbers. That the biggest one that the SEC has paid is equivalent to Bradley Birkenfeld's at the IRS, $100 million. But they have taken on board and really expedited their process. And this year in particular, they've already awarded 40 whistleblowers rewards to date, which is the exact same amount they had done in total last year. So we're not even halfway through the year. So they've made some real changes to expedite, and it's clear that those are working. So they are evolving and taking on board criticism and becoming a better program. Here's for the CFTC program. They awarded 15 whistleblowers since the beginning. CFTC is a smaller agency, so hence the smaller numbers, but still significant. And most importantly, as I keep beating the drum of loving to see HMRC moved from a discretionary to a mandatory program, we have paid, the IRS has paid $1.02 billion to whistleblowers, and their return on investment, that's 16.5% of the $6.14 billion that they've helped them return to the Treasury. So I would say that's a good return on investment. And so I think that's it. I will stop sharing my screen and open up to questions.
Mary, thank you very much indeed for that. I have to say something that I was completely unaware of, frankly, something I don't know very much about at all. Kevin asks, are you happy to share those slides? And if so, I'll get them from you and I'll share them around. That's brilliant. If people want to ask questions, yeah, as Kevin just has, please feel free to raise your hand and I'll just call on you, unmute yourself and ask it. So Kevin, please go ahead.
Hi, thank you both for the presentation. I'm just wondering whether the lack of financial incentives in the UK is a result of a cultural difference. I don't want to engage in cultural stereotypes, but the American experience seems to reward whistleblowers with cash and money being very important. Here in the UK, there's a much more recalcitrant attitude, I think, to give anything to a whistleblower, save for, in essence, loss of earnings and any injury to feelings. I just wonder if the speakers believe there's a cultural difference that is stopping the UK from adopting the financial incentive approach of the US.
I'm happy to go first. I know John will have a view here as well. So it's been my experience in my 3.5 to 4 years being in the UK that there's almost I've experienced the cultural differences. And I think it's that, rightly or more wrongly, and I think we have to engage in the stereotypes, Americans are perceived as overly mercenary and capitalism unchecked. And so I think there's a perception that, oh my God, Americans, you have to pay people to do the right thing. We're British, we do it because it's the right thing to do. When you unpack that a little bit, and I think that has led to some pretty sloppy thinking, that people stayed in the world of stereotypes and haven't sort of pressed further. But my experience in working with the APPG for whistleblowing, in using Baroness Grahame as an example, is that when she learned about it and she became more educated, and in fact, when I had my British partner make the presentation as opposed to the enthusiastic American, she came to see and view rewards for what we believe them to be, which is that they are basically the net present value of a career loss, right? Whistleblowers, as John attested, suffer blacklisting, blackballing. And so the retaliation protections, unfortunately, if you can be that 10% that wins in the employment tribunal, that only helps you as to discrimination by or retaliation by that one employer, not the prospective employers, the future ones that will go on and on and on to continue to brand you the whistleblower and consider you radioactive. So the rewards seek to do that. My clients aren't motivated by the money. I think there's this perception that because you're an American whistleblower, you're motivated by the money. The money helps them in that conversation they're going to have with their spouse. Say, are you crazy? You're going to undertake all these risks without any potential return. It's just something that helps to hopefully tip them onto the better side of their angels to bring a reward, bring a case and have the potential for a reward. So I do think that stereotypes underpin it. And I think the more British people understand it, the more they define it, as Baroness Grahame does, as unemployment insurance.
Can I just add a couple of things? I think, Kevin, you're right. I think it is a cultural thing. And you can imagine the cross-examination that there'd be if people were being given very large sums as to whether they're doing it for opportunistic reasons. I think there is also a fear that it might create antagonism with other employees who felt that people shouldn't be getting particularly these millions of pounds or dollars. So I think it does need to be looked at very carefully. But I mean, as Mary says, there are some people already who are getting small sums from HMRC, and I think there's one from the whatever the Monopolies Commission is now called as well, and also obviously Crime Stoppers and so on.
Right, the Competition and Markets Authority pays £100,000 to guarantee to whistleblowers who expose cartel-type behavior. I think in recognition for the fact is you're not going to bust a cartel without an insider, but there's considerable cost to that insider in speaking up. It's not just that one employer; it's all the employers who, businesses who conspire. I think it's really important. To John's point, we've already crossed the Rubicon of dealing with witnesses whose credibility can be tarnished by the fact that they have a financial incentive. I think that is only relevant in cases where it's that one particular whistleblower's testimony against somebody else's. The vast majority of my cases are ones where the whistleblower never needs to testify because we have lots of other witnesses who corroborate or other documents. So I don't think that should be the concern. And in terms of what it creates in the workplace, I can tell you that it may not be the environment that people want, but I can say that a lot of whistleblowers now start bringing whistleblower actions defensively because they're less concerned about the regulator as the initial start of the investigation, but of the people in the cubicle next to them who are incentivized to come forward. So it has led to, I think, a culture of compliance and more internal self-regulation by virtue of fear that your cohort in the cubicle beside you is going to head to the SEC.
How interesting. Paul, you had your hand up.
Yeah, thank you, Grahame. I just wondered if John and Mary, you could comment on a view that I've often heard expressed, and I tend to have a lot of sympathy with, which is that the fundamental structure of the UK system is to pit the individual whistleblower against the perpetrator, where they have to report, first of all, to the wrongdoer and face career ruin, reputational ruin, and essentially have to investigate the perpetrator on their own, as opposed to and be cross-examined as to their motives, as opposed to the US system and the system in a number of other jurisdictions where the whistleblower is not in the room. The whistleblower is anonymous. The whistleblower is an informant who provides information, and it's for the state, who will be handsomely rewarded from successful investigations in terms of recovering state money, that pits its state against the perpetrator, not the individual. And if we think about a case of furlough fraud, why should the millions and tens of millions of pounds of furlough fraud in the last few months start off with you having to report to your employer the fraud who's committing the fraud? Why shouldn't you be able to say to the government, I'm afraid there is this furlough fraud going on. I don't want to be named. I want to be anonymous. I want no one to know. Can you investigate? So it seems to me that is a fundamental difference that strikes at the heart of this. I wondered what you think.
I would just say really quickly that it's a really important question and a concern that people raise, that if you offer rewards to whistleblowers, will it undermine the internal reporting mechanisms that employers have set up, right? That the seniors managers regime is required with its whistleblower champions and its, anonymous hotlines. And the evidence, and even the EU whistleblowing directive, has not made it a requirement that you have to report it internally first in order to be eligible to go external. And the reason for that is that while we encourage our employees, our whistleblower potential clients, to report internally where it seems viable, there'll be plenty of times with the very people they're reporting to are the perpetrators, right? So they're just setting themselves up for that kind of career harm. So I do think so the way the SEC cuts that is they say, we will consider that as a plus factor when we consider in that 10 to 30% award range that you get. If you report it internally, we'll give you a bonus for that because we want to encourage that behavior where it is permissible. But so that's sort of how we've struck the balance. But you're right, the fact that the SEC and the agency programs, not the False Claims Act, because you are a party to the action, so you have to be identified, but you are anonymous. You can file anonymously with the SEC. And if you'll see, when they advertise their rewards, they never identify who the whistleblower was or what they paid, what action they paid the reward in. So I do think that the anonymity is a very powerful tool and encourage people to come forward, because you don't necessarily have to destroy your career.
Yeah, I mean, I think, Paul, you've touched on the very important point that I was trying to get to by saying that what we have is a pure employment model, and we should be looking more to a regulatory model, or at least trying to meld the two, because the employment model does require the employee to investigate to the extent that they have a reasonable belief, and then go to the employer before going outside. The only thing that I would say is that anonymity can breed its own difficulties, because if you remain anonymous, it can then become difficult for the regulator to investigate. But there are obviously potential channels for having that anonymity to be only as far as, or the name to be known to the regulator, and not more widely. But I think also this is linked to the possibility of having an office of whistleblower who could effectively act on behalf of whistleblowers and help them along. What we have at the moment is a very adversarial system requiring investigation, and I think the next move needs to be a different sort of structure.
I think Kevin's got his hand up again, but before I go to him, Sally has asked what I think is a very interesting question. Mary, how does it work? And John and Mary, how ought it to work when we're talking about things that aren't big money domains, like, as Sally says, abuse in care homes, for example? Sorry, Sally, I didn't mean to ask your question when you're perfectly capable of doing it yourself. It's just that you put it in the chat. You're muted.
There are things that flow on from that I'm interested in, because I've been writing about this. So can I ask them all at once? Because I think some of this is sort of blending and merging. We do have whistleblower protection in this country. What we don't have is a sufficiently normative regime in our financial institutions, just to keep the finances on one side, as the Americans. The USA has always had much stricter legislative controls on fiscal wrongdoing. So that is why, after the financial crisis, they had a lot more sanctions at their disposal than we did. So, and you can see that in the investigations, because the UK relied a lot on the spade work put in by the US to reveal things like the LIBOR scandal. All those sorts of things emerged much better because there's much better a base regime for financial misconduct. So we've been running to catch up in that respect, in my opinion. But to go back to things like other types of corruption, where we do have whistleblower legislation, and you can tell on people in the health service or in care homes and so on, but you're still a marked person, because anonymity is very, very difficult to preserve, where you can only be one or two people who may have reported. So that's one issue. It brings a new ethos. I can quite see that in financial crime, you know, the SEC and all those institutions that is very easily in the normative structure. You know, money is the commodity, and fair dues, you know, if somebody picks up on it and finds a different way of shuffling the pennies around, then I can quite see the logic of that in terms of people's interaction or why they should get those rewards. But getting into these other areas where corruption is just as important as safety in the building industry, blacklists were operated, it's very, very hard to find a legal or juristic type of solution to it.
I agree, Sally, and I think you know, our programs are not the solution to everything, but I do think there's an embedded misperception here, which is that our programs don't only deal with financial wrongdoing. So a couple of the programs I didn't talk about, there's one under the Motor Vehicle Safety Act. It came, so whistleblowers who work at part suppliers or car manufacturers who know about defects that imperil lives of the passengers or drivers can bring information to the Department of Transportation and receive, again, 10 to 30% of the recovery. So we're not just doing this in the space of financial services, for one. And as a result of the Boeing 737 debacle, we have legislation pushing for one similar program within the Federal Aviation Administration. So we have gone beyond, and again, I think that's part of the evolution of our programs. Of course, one of the differences that we do get at Medicare fraud and Medicaid fraud, because there's private contractors involved. I know with the National Health Service, that tends not to be the case, although as I understand it, a lot of there is some privatization going on, and I've noticed some American healthcare companies like United Health Group, folks that we're actually suing, have been brought into much to my dismay, to the NHS model. So I do think there could be a role in the delivery of healthcare systems to go after private contractors, and I would encourage that kind of use. So we don't have all the answers, but part of what I think the Office of the Whistleblower seeks to do is create, I mean, we could use some of the funds that come from these massive fines to that the FCA or the SFO could be imposing, or HMRC, to create a fund for whistleblowers more generally and more broadly. We don't have all the answers in the US, because one of the biggest blind spots for us, of course, is we will not pay. The government loves whistleblowers when they're helping them, when the government's a victim and they're helping expose frauds. We don't pay whistleblowers when they're in the national security, or, you know, they were in the Trump administration and exposing Ukraine and other problems. So we're working towards that. We know that we have to improve. We work with a group called the Government Accountability Project that John referenced to try and move for rewards in those areas too. So we're trying to learn how to do it. And that's part of why I'm really pleased to be part of the work with the all-party parliamentary group to figure out, I'd love to bring home some learnings on what an Office of the Whistleblower or Whistleblower Commissioner could look like. Because we don't have it. It's all segment. It's very compartmentalized in the US.
So, Sally, I think the answer to your question may lie back in 1826, when the power was given to Crown Court judges to offer rewards to people who gave information that led to people being convicted. Bizarrely, the maximum still stands at £250. I mean, what you could do is to have no one's going to give up the job for that. What you could do is to give a power to employment tribunals, which may listen to the whole case and therefore know the value of the information given, or more likely to an office for whistleblowing. So you would have a fund that wouldn't be a percentage like it is in the US, but would be an amount to be determined by somebody of or a group of people of wisdom. And I would thought gradually over time some sort of principles would develop, but it wouldn't be easy, because, you know, how do you equiparate, as you say in your question, someone who gives information that deals with abuse in care homes to somebody who gives a tip to the HMRC, which may lead to a lot of recovery.
Great.
And there's also, if I can come back on that slightly, there is a double penalty about going to the employment tribunal, in that there is still, you are then, you've got to, you doubly expose yourself to more discrimination. I mean, it's a well-known fact that bringing a tribunal claim, no matter what the context, can mark you out for future employment as a troublemaker. So where does the retaliation end?
Because this isn't confined to whistleblowing, it's
exactly.
particularly whistleblowing, but people report, obviously, if they've brought discrimination claims or even a common or garden unfair dismissal, that they become less attractive to future employers. And what we don't have specifically in the whistleblowing provisions at the moment is the victimization claim that, as you probably know, you can bring in the discrimination area, and it simply doesn't apply to people who are applying for jobs, only if you are in jobs.
I would note, Sally, sorry, Graham, I would note, Sally, too, that Canada and the European Union have now taken really important steps that I've been pushing for the United States to adopt, and I've been whispering in ears, hoping that the UK would move forward with this, which is a reversal of the burden of proof for retaliation cases. So the Ontario Securities Commission, which has the identical situation reward program to the SEC's, like the SEC, it has an anti-reprisal retaliation protection, but it reverses the burden. And that is what also happens in the EU directive, which will ultimately be transposed by the 27 member states by the end of this year, supposedly. We'll see. But that really is a game changer, right? Because you're now moving the onus, right? That it's always the whistleblower, and what happens to whistleblowers routinely, as we all know, is that as soon as, it's shoot the messenger, you bring forth the information, and instead of, and you're acting in a way, you're acting on behalf of the state, which is part of, I think, what Paul was getting at. And what you're met with, instead of applause, which is what you expected, that's what my job asks me to do. They start digging into you. All of a sudden, it's you had great performance reviews, but now all of a sudden we're going to go looking back at your expense reports and anything, and to try and dig up dirt on you. So then it becomes very easy, when the burden's the other way, for an employer to say, oh, I didn't fire them for the whistleblowing. I fired them because they're routinely late. John Banerjee was the Royal Bank of Canada whistleblower who actually won an employment tribunal. They tried to raise this argument. Luckily, the employment tribunal said, he's been late perennially. He was late for years. You never were concerned yourself about him being late until he blew the whistle. So when you reverse the burden of the proof, it's all of a sudden the burden's on the employer to say, that is why I fired them for some other reason. And I think that's significant. If we could move toward that, that would be a huge step forward.
Going to go to Martin and then Deba. So Martin Fodder.
Is a powerful one. That the system requires, or is at least structured towards directing the worker to make the disclosure to their own employer. But that is true. But there is a philosophy behind that, of course, which is that the employer is usually, not always, but usually going to be the person who's best placed to take rapid action to investigate the concern. Not only as to what has happened, but why it's happened, but also to prevent it recurring or carrying on. And if you take the driver towards the imperative away from the worker being directed to go to the employer first of all, and require them or direct them towards a third-party regulator or some sort of external agency, that may slow down the process that you actually want to speed up and encourage, especially if, and here's the cynic coming out, that external investigator isn't particularly well funded and doesn't have the expertise that will lie within the employer. If the employer is the NHS or whatever, they're the best placed people to investigate, surely. And it isn't as if the whistleblower who does fear that they will be subject to retaliation if they go to their employer doesn't have alternative courses through 43F or 43G. And I accept that the hurdles may be higher, but they are there to be surmounted if the concerns are sufficiently well-founded and serious. So I don't think the argument's all one way. That would be my suggestion.
Martin, I agree, but I would hit you with some data, which is that the experience, and that was a concern that when we rolled out these programs, as I said, we're concerned that people would bypass internal procedures, which is what we want them to do. We want the employer to have an opportunity to correct. The SEC reports 84% of all whistleblowers who report to them have reported internally first. And the reason for that is more just there's something about people don't want to give up their careers for the prospect of a lottery ticket. And it's just been borne out in the data that whistleblowers want, they've been trained to do this job. They don't want to give it up, and they want they want the company to do the right thing. So there's almost just a natural tendency that seems to be curbing this concern that people have. Of course, we have malicious prosecution and other vehicles if someone brings something inappropriately, but that hasn't been the case. It's not what we've seen. So I think the worry is that if you make it prescriptive, and look at Just Staley, right? The Just Staley example, senior managers regime now requires internal reporting. Barclays Bank gets a state-of-the-art internal reporting system that allows for anonymous reporting. What's the first thing that Staley does when an anonymous report of cronyism comes in? He hired a crony. He tries to figure out who the whistleblower is. He goes Trump with the Ukraine whistleblower. Who is it? And so, okay, maybe you forgive him the first time he didn't attend the training. He doubled down when he was advised. And that's just the instinct. So that's the problem, is that until the culture in these organizations is embracing of whistleblowers as forward indicators of risks, of actually allies who can help you identify problems before they metastasize, until that change happens, it's hard to report internally. We need to change how they're received. There's some great empirical data out of George Washington University that took Navex Global, the #1 provider of hotlines worldwide, and said that companies who have active whistleblower hotlines are more profitable, have fewer investigations, and the lawsuits they have settle for less than those who have silent hotlines. The idea being, to support this cultural change, that whistleblowers help you. They're your allies, not liabilities. But we aren't there yet, because there's still this autoimmune response by employers, and your employment lawyers, Paul, I'm sure can tell us all, that they want to expel the messenger and don't understand that they're the good bacteria that helps you.
Yeah, Mary, and I Martin, I was sort of thinking, what percentage of grievance reports are upheld when an individual reports their employer and says, look, I think there's been a breach. And, in my experience, it's a tiny proportion of grievances. So there you have the cultural play. An employer is going to do anything but find that there has been, at most, usually a grievance. If there is a grievance upheld, it usually says something like, oh, well, we could have communicated a bit better, but no, there was nothing untoward in what we did. So I do wonder whether it really is enough.
I think, Martin, you're right. There are two sides to this issue, but I think the way I look at it is that the whistleblowing legislation simply isn't working at the moment. So we need a new model, and the model, it seems to me, is to avoid what Paul is talking about, the reporting which leads to the employee being overexposed is highly unlikely to lead to the grievance being upheld. But I do think that the role of the regulator is key to this, because if you actually speak to whistleblowers, one of their biggest grievances is that they laid down their career and the regulator wasn't particularly interested in what they said. And so I think a duty on employers to investigate, which would be an independent legal duty of the duty in qua the employment contract, and also a duty on regulators. Grahame, I think you've got a few other people to get in, haven't you?
Yes, I think last question, Diba.
Hi all, forgive me for keeping my camera off. I'm still in my pajamas. Really interesting talks. My question is more focused at John and your talk. I was really keen to hear what you had to say about harassment and discrimination, which is what I do. I work with women who are bringing sexual harassment cases, and what we know is all the same problems that we've addressed, the lack of grievances being upheld, the fact that you have to go to the perpetrator, it's all similar issues. I know you've said that I think it's Protect to put a new draft bill down. How would that change victimization? And just selfishly, how would that be relevant to my work? And then could I just ask you to expand on what you were saying about NDAs, because we know so many people, that's where they will end up in a settlement situation. So where do you stand on that? And then if you can get this in, what you were saying about criminal sanctions, I found that really interesting. So how would that work, and what would you be proposing?
Well, very briefly on each of those. I'm not certain the present status of the Protect bill, but they were talking about, because it's gone through various iterations, they were talking about having a wider victimization provision based on discrimination, so that if someone suffered a detriment by reason of having whistleblown, that would be a separate ground of claim. NDAs, we could probably have another hour on this very difficult area, but I certainly think the law should on not allowing non-disclosure agreements. The downside to that is that it would discourage many employers from settling if everything that was alleged, of course true or not, could then be in the papers. You're a glutton for punishment, Deepa. You want a whole NDA event, you say in the chat. And then on the last one, on criminal sanctions, I mean, I think the reality is, and of course we're talking about small employers to very large employers. Many will not sit up and listen unless there is a criminal sanction, or actually, as has been very effective in relation to minimum wage, a name and shame register to go along with that. I mean, the problem with criminal sanctions is that it requires prosecution authorities that are willing to prosecute, and many do not do not pursue the criminal offences that are presently available. But I certainly think we need to do some new thinking in this area, and criminal sanctions are one aspect of that.
Great. Well, thank you all. Extremely interesting discussion, and I'm very grateful both to John and to Mary for joining us and speaking to us. I think we may have just lost Mary, actually. But there we go. Very interesting talk. We are going to have, at the end of April, a talk with David Reed about the gig economy. David was for a time involved in the Uber litigation and has a very deep knowledge of that. So I'll of course be sending around information about that. I should say that if there are, just as Deepa has suggested we have an NDA event, if there are talks that you want to organise or speak at, or topics you want to speak on, or anything like that, just get in touch and we'll make something happen. So thanks once again to John. Thank you to Paul for the connection with Mary, and to Mary if she can still hear us maybe. Lovely to see you all, and have a lovely evening. Thank you very much.
Thank you.
Bye.
Bye-bye.